Good afternoon. Just a little over 1 month ago, the United States Supreme Court issued a strong opinion on freedom of the speech in America. Today, it's First Amendment Day on the campus at Iowa State University. It's a day set aside to celebrate, but most of all to think about the 5 freedoms that are enshrined in the First Amendment. One of those 5, of course, is the freedom of speech. So what better occasion than to think about and discuss that recent Supreme Court decision. Joining us for that discussion are 4 nationally known experts on the First Amendment. Let me introduce them, and then we'll get on with the discussion. Jeffrey Hunt is a lawyer who specializes in First Amendment and media law with the firm of Parr, Brown, G. and Loveless in Salt Lake City. Frank Lamont is executive director of the Student Press Law Center in Arlington, Virginia. Gene Policinski is executive director of the First Amendment Center, which has offices at Vanderbilt University in Tennessee and in Washington, D.C. And Adam Kissel is vice president of programs with FIRE, which is the Foundation for Individual Rights in Education. They have offices in Philadelphia and New York. And my name is Richard Doak. I'm a member of the First Amendment Day Committee on campus, and will try to moderate this discussion. The Supreme Court, the case in question is Snyder versus Phelps. It involved the controversial Westboro Baptist Church and its practice of picketing the funerals of American soldiers killed in Iraq and Afghanistan. Let's first ask our panel to fill us in on that decision and tell us whether the Supreme Court got it right. Let's start with Jeff Hunt. Jeff, could you just give us sort of an overview of the case and the decision?
Sure. So the Westboro Baptist Church for the past 20 years has picketed military funerals to communicate its belief that God hates the United States for its tolerance of homosexuality, particularly in America's military. That's why they focus on the military funerals. The church's picketing has also condemned the Catholic Church for scandals involving its clergy. Fred Phelps, who founded the church, and 6 Westboro Baptist parishioners, all relatives of Phelps. It seems that most of the church is made up of relatives, traveled to Maryland to picket the funeral of Marine Lance Corporal Matthew Snyder, who was killed in Iraq in the line of duty. The picketing, and this is important for purposes of the decision, took place on public land, approximately 1,000 feet from the church where the funeral was held, in accordance with guidance from local law enforcement officers who the Phelps had met with before they picketed. The picketers displayed their signs peacefully, but the content of the signs was pretty outrageous content. And I'm going to describe for you what the sign said because I think it's important to the decision. One of the signs said, "Thank God for dead soldiers," "Fags doom nations," "America is doomed," "Priests rape boys," and "You're going to hell." Those were the types of signs that were displayed by the Phelps at the protest. The protest lasted about 30 minutes before the funeral began. Matthew Snyder's father saw the tops of the picketer signs while he was driving to the funeral, but did not learn what was written on those signs until watching the news broadcast later that night. Mr. Snyder filed a lawsuit against the Phelps and his daughters who attended the protest and participated in the picketing, and he filed a lawsuit. Included in that lawsuit was the church itself. And they alleged, the Phelps alleged various claims, or Mr. Snyder rather alleged various claims. Claim for defamation, which got thrown out by the trial court, but most relevant for purposes of the Supreme Court decision, a claim for intentional infliction of emotional distress, intrusion upon seclusion, and civil conspiracy. A jury held Westboro liable for millions of dollars in compensatory and punitive damages. Westboro challenged the verdict as excessive and also sought judgment as a matter of law on the grounds that the speech that they engaged in was fully protected by the First Amendment. The district court reduced the punitive damage award but left the verdict otherwise intact. The Phelps then appealed to the Intermediate Appellate Court, which was the Fourth Circuit Court of Appeals. The Fourth Circuit Court of Appeals reversed the holding of the district court and found that the Westboro Baptist Church statements were entitled to First Amendment protection because they were matters of public concern. They were not provably false, and they were expressed in hyperbolic rhetorical terms. So that is the decision that went to the United States Supreme Court, the Fourth Circuit's decision finding that speech was protected. And the United States Supreme Court affirmed the decision of the Fourth Circuit. They found that the speech did involve matters of public concern, and that under the First Amendment you cannot penalize that speech or hold someone liable and impose damages for that type of speech.
Let's hear from the rest of the panel on the question, did the Supreme Court get it right? Frank?
Yeah, I think this is one of these cases, and you see this coming across in the Supreme Court's decision that was factually a gut-wrenching case for everybody involved, including me, including all of us in the First Amendment community. Factually a repulsive case, but legally, quite frankly, a pretty easy case on the legal principle. I mean, once you get over the threshold that this was speech addressing itself primarily to matters of public concern, to military policy, to gay rights, to moral and religious issues. Once you get over the threshold that it's speech as to a matter of public concern, then to hold otherwise, to hold in favor of the Snyder family, really would have been to say that there are some ways to express yourself on a matter of public concern that are just so terrible that you can't ever say them anywhere on the face of the earth, because this was speech that was far enough removed from the funeral that it didn't actually disrupt the conduct of the funeral at all. That would have been quite a different case. But the dispositive fact was that the Snyder family didn't learn about this until seeing the speech afterward on the internet. And so since there's nowhere that you could engage in speech that you can't be sure that someone won't see it on the internet, right? There's nowhere that you can engage in speech to be sure that it won't be seen on the evening news afterward by somebody. It really would have been a ruling saying you just can't say this anytime, any place on the face of the earth. And I think that would have been an untenable proposition under the First Amendment. So I think doctrinally it was rightly decided, no matter how terrible of a taste it leaves in all of our mouths factually.
Adam?
Well, I can't disagree with the decision either. I agree that it was pretty simple, and I'm not even an attorney. And so I think even from the perspective of someone who knows a lot of First Amendment cases from a non-lawyer's perspective, Fire wrote a brief on the Phelps' side for pretty much the same reason that Frank brought up. One of the interesting things that made it a more complicated decision from the beginning was that way back at the beginning, one of the signs said, "God hates you." And so the trial judge basically says, well, that could have been against the Snyder family, and so we're going to let the jury decide that. And so if they really meant you, the Snyders, without even like making a distinction between the person who had died and the rest of the family, maybe there is enough there for kind of a personal attack that the jury would get to decide instead of, as a matter of law, saying it was just protected. But by the time we get to the Supreme Court, that had already kind of fallen out as a question, I think.
Gene?
Well, if I may, I'm going to fill 2 chairs, so I'd like to reserve a couple of minutes, just maybe a minute or 2 after I finish the task of really, in effect, representing the Phelps family, which isn't represented here. And I say that represented in terms of just telling you about an interview I did with Margie Phelps a little over 2 weeks ago at the College Media Advisors. And I asked her some of the questions that I think have been posed here and that came up in the Supreme Court. And basically, are there funerals that you wouldn't go to? Where won't you go? And why did you win? And where do you think it's going from here? I will tell you that they think they won because even though America is doomed, which is their message, by our conduct, they actually don't think that they're out there saving anybody but the occasional, as she put it, stray lamb. She really thinks that we're past the point as a nation. And they continue to do that because she thinks there's the possibility 1 or 2 people out of 310 million people might be saved. So they sort of reserve that position. They basically say they're just basically telling all of us that we're doomed because of our past conduct. And they think that they are not there to inflict emotional distress on the subject of their protest, if you will. They see their message of salvation as they did to, they saw the Snyder case, telling the Snyder family, in effect, where they have gone wrong and where they might redeem themselves by presumably the Snyder family repudiating their past conduct, if you will. They see themselves as bringing a public message on public property according to law. They're very careful. They called ahead. They actually obeyed a Maryland law that was not yet in effect about public protest. They stayed a distance away that was not yet really codified. The law hadn't gone into effect. They see themselves as she put it, 50 people against 310 million. And they think that's exactly what the First Amendment ought to protect. And they think that's why they won in the Supreme Court. They also are very good tacticians, I will tell you. A great many of the family members are lawyers. They, in effect, are a law firm with one client on one issue. And so they know the doctrine ranging from captive audience to any number of First Amendment particulars very well. And most people who covered their case in the Supreme Court and covered the argument by Margie Phelps thought she did an extremely good job of being an advocate for their side. And there was some expectation, frankly, that she wouldn't be. And I think the reporters on a tactical level, really thought she did a good job. In terms of reacting, as my colleagues have done, I think the next issues, there are a couple of them. We're seeing a Supreme Court that has moved the issue of private and public person toward a consideration now of public issue, so that you might engage private citizens in a way they might have been sheltered from before. But as long as you are discussing a public issue or an issue of public interest or concern, they've moved the attention. The original, I think, intent of that lawsuit was to argue Mr. Snyder was a private individual, and therefore some of the things that a public figure would have to endure, he did not have to endure. Well, the court really shifted in their decision off to this issue of when I decide, as opposed to the person who might be impacted, when I decide to speak, if it's on a matter of public interest, I drag First Amendment protection along with me. And I also think we're going to see the next round of lawsuits be on the time, place, and manner restrictions on 100 feet, 500 feet, 2,500 feet, an hour before and after the funeral, 2 hours or 3 hours, in direct line of sight or not direct line of sight. But again, the Phelps family is very good at consulting with local officials and making sure that they're obeying local ordinances and obeying the instructions of police. In fact, there are some people who allege that they support their public protests by, in effect, engineering settlements with people who unfairly restrict their rights to protest, and then they reach a settlement out of court, and that's how they fund the next round of public protests. I wasn't able to get anything from her confirming or denying that, but they have had settlements because people have reacted emotionally, restricted or prevented them from speaking, and they have won in either in court or more likely in out-of-court settlements. So it's an interesting case for a variety of reasons, but I will tell you that the family feels no remorse whatsoever over what we would think is the infliction of emotional distress or pain, just to put it in less legal terms, because they see themselves as bringing a religious message, and in the manner of which a preacher on the street might say to you're all sinners, you need to be redeemed. At some emotional level, I suppose that hurts a little bit if you take them seriously. They see themselves in that fashion. They're bringing an unpopular message to people who need to hear their message. And they think that is properly protected speech, and the Supreme Court, for a variety of reasons, in this particular case, with this particular set of facts, agreed with them.
Adam, did you have a comment?
I just wanted to raise a question about the public versus private question. So let's say someone is telling everyone, you're all sinners, and then someone says, what about me? And yeah, you too. Well, now I've gone from kind of a public statement about kind of a matter of public concern, the United States is a bunch of sinners, to, well, you are too. So there's the whole, and then, well, you're part of that whole, and so you're that private individual. And so I think that's kind of what's going on with the picketing of military funerals, too. It's not that it was Snyder in particular, it was, here's just another example of what we do. But then Snyder also took it personally because it was true. It was his own son. So I bring that up as a question of public versus private.
Well, again, one of the defenses raised in the Supreme Court and that she raised in the discussion with me is that it was interesting. I asked her, was there a place where she wouldn't go, where the family wouldn't go? And they said, a truly private funeral. So the journalist in me said, what is a truly private funeral to you? And it turns out that a funeral, even which you might have a one-line listing of an obituary, ceases to become a truly private service to them. That by placing one line, maybe the name, first and last name, and the time and date of a funeral service makes it, to their idea, a public event. Now, they say about military funerals, but also, they've gone to the funerals of EMTs who have died in crashes where the helicopter goes down en route to aid someone. They go to a number of types of funerals. They threatened to go to Liz Taylor's funeral. I'm not sure if they did. They threatened to go to some of the funerals in Arizona following the shootings there involving the congressman and the judge. But they would contend all of these are public events at which they have a right to appear. So they actually, the Supreme Court went, to me, a little bit further in moving this off of public and private figure into this issue of public significance. Because even to some degree, I don't think the Phelps family was really relying on that. It just was a little bonus that they got in a way from the court.
Jeff?
Just to pick up on Adam's comment, that is precisely the argument that they made, was that this was a personal attack and you're trying to immunize a hurtful personal attack by dressing it up as sort of a public issue, and it's really not. And what the Supreme Court said, to determine whether it's public or private speech, you need to look at the form, the content, and the context. All of those factors go into whether it's public or not. And looking at those factors, they said there was no pre-existing relationship between the Phelps and the Snyders. So it wasn't like this was a feud that they had engaged in any kind of communication before. And the church had a 20-year history prior to this funeral of picketing military funerals. So it was pretty clear that they didn't target the Snyders, themselves. It was part of their pattern and practice of getting their public message out in a hateful, hurtful way. But that's what the First Amendment is there to protect, is that type of uncomfortable speech that can be hurtful, can be very painful, as in this case. I mean, we don't need the First Amendment to protect the speech that we all like. It's for this type of speech, and this is a similar case on the facts to Texas versus Johnson, the flag burning case, which really brings out strong emotions. In fact, I think Justice Stevens dissented in that case, who traditionally very strong supporter of the First Amendment. So these types of cases bring out passions in people, but the fact that it was decided 8-1, tells you that this type of issue, the First Amendment, really transcends conservative and liberal judicial philosophies. And that gives me a lot of hope for this court, that this is a court that recognizes the importance of the First Amendment and is willing to stand up for it in a really tough case.
A similar question on this question of personal versus public. As I understand it, part of the grounds for this suit was invasion of privacy. And here you have a situation where this is a private funeral, private people are attending it, but this outside group comes in, picks up this private family essentially, and injects them against their will into a public issue that they want no part of. Is that right? Should that be allowed?
Well, I think this is where the court made this shift and pivoted away from really the focal point being the Snyders as a private individual, and said these are matters of public interest. And also, it gets into the captive audience and really the idea that you can avert your eye. This, I think, as Frank said, would have been a very different case, and both in the interview and then in the court. The Phelps family made a point of saying, we never physically disrupted the funeral. Margie's language was, we never got in their grill. And she drew a distinction between abortion protesters, for example, where they might get right up to a person. They were gone, in effect gone by the time the heart of that funeral service took place. And they're saying, in effect, we never did do that intrusion on the truly private aspect of this. They would still allege a public ceremony. So even they recognized this boundary, perhaps for reasons more than moral, but they recognized it. And, it would have been a terribly different case if they had gone into the funeral, blocked the only ingress and egress, the doorway, for example, or stood right there, but they didn't. They stood back. And, again, I think it's an important thing, as my colleagues have said about this, that, nobody celebrates this case, I think, on the First Amendment side in terms of the facts or the Snyder family. But you have to say the right of individuals to say an unpopular thing in public when it offends almost all of us is something hallowed. And I'm going to get myself in trouble here. So I want to carefully distinguish that I'm not answering this phone call, that I'm not, but I'm also not comparing the Phelps family to these next groups I'm going to cite. But, we forget that advocates for children's rights and safety, people who advocated for women's rights, for civil rights, for immigrant rights, for labor rights, have said things in public venues and in some degree inflicted emotional distress or at least intellectual distress on individuals throughout our history. You think Martin Luther King was not inflicting some kind of emotional distress when he talked about the hate and bigotry of public officials and majorities in communities where he often would speak? He was. And I shudder to think what would have happened had they been able to use this argument raised here to say, it makes me feel bad, and I'm not trying to be glib, but it brings me pain, a deeply held moral position that I have, even though you and I might think it's immoral. And because I am offended, you have to be quiet. And the Supreme Court specifically said you cannot punish the speaker because of that pain, as much as we empathize with the Snyder family. The First Amendment has never been easy. This case is one more reminder that it isn't.
The Phelps family members are lawyers, as I understand it, and are pretty good about knowing where the line is. There is an argument that the First Amendment was intended to protect political speech. That is, speech that's intended to debate public issues and change people's minds, to persuade people. That's the purpose of the First Amendment. But there is this other kind of speech that is not intended to change anybody's mind. It's intended to inflict hurt on people. Words used as a weapon. You've mentioned that a little, but does that apply in this case? Is it really political speech when your protest is meant to inflict pain on individuals, not to change anybody's mind?
There's this interesting case. Well, parody is by its own nature designed to inflict a certain amount of ridicule and harm on the target. And so this great case where Hustler magazine made a lot of fun of Jerry Falwell and his mother, basically saying that the two of them had sex in an outhouse and she was dead and infested with flies. And no one ever thought that was true. Nobody in their right mind ever would have thought that Hustler was really saying that was true. So the entire point of it was to make fun of Jerry Falwell, but not necessarily even to make him feel bad himself, but in Hustler to tell a joke, probably, to make people, readers of Hustler, laugh, but also at Falwell. So, I mean, but the Supreme Court said, that's protected too. And how can you say that there's no other value to the speech other than merely to make somebody feel bad? Well, in that case, they were doing something else. They were telling a funny story that to them was funny.
It's interesting, Justice Rehnquist wrote that decision and Justice Roberts wrote the Phelps decision. So two people you wouldn't normally hold up as a paradigm of sort of unrestricted speech, but in both cases written by the chief.
I think what you're talking about, or what you characterize as political speech, is really what the court is talking about as speech of public concern. That is speech that is important to self-governance. It's speech about matters that help us understand our lives better and help us govern ourselves better, as opposed to purely private speech, as in the Dun and Bradstreet case, which had to do with the credit report of a particular individual. That's only of importance to that individual. It shouldn't be of importance to everybody else. So I think that the court is really saying that if it's a matter of public concern, the speech relates to a matter of public concern, and there's some fuzziness about that, but they give some guidelines for deciding what that is, then that is at the core of the First Amendment and entitled to the highest protection.
You also mentioned it 8-1 on this decision, very strong on one side. We're used to seeing the Supreme Court split 5-4 along conservative liberal lines. Is this a good sign that they can come together on the First Amendment?
Well, it's always dangerous to predict the Supreme Court, even if they've done 50 times this way. You really don't know what they're going to do the 51st time. I think there was, again, not an easy decision here because you read the transcript of the oral argument and the decision, and it sort of drips with, oh, geez, do we have to do this? But I think in terms of, as Frank said, in terms of the law, it was a fairly obvious path for the justices. Justice Alito essentially, I think, took the empathy for the family and made that preeminent. I think the other justices started where I hope they always start, which is that we're not starting from the middle. We're not starting from 50-50 when it comes to the First Amendment. The government has to demonstrate this overriding reason to suppress our speech. So I think for most individuals, you sort of start out in the middle. Is this a good idea or a bad idea? We don't start that way, thankfully, with the First Amendment. I get to say what I want, unless there's this overriding reason to stop me. And that's, I think, why we had an 8-1. If it had just decided on would we rather or not, I'm not sure, we would have got the same decision. But again, thankfully we don't. I don't know. What do you think the presages for the court?
I mean, I think that the other thing you can't ignore and you can't divorce yourself from here is that although it's not any sort of a recognized religious denomination that any of us would consider to be mainstream, this was, after all, religious speech. And so you have people like Justice Thomas and Justice Scalia who are highly conservative and who normally perhaps you wouldn't think would be terribly solicitous of a small minority viewpoint, right? But they are solicitous of religious speech because they know quite well that over our history it has been religious speech that is very often singled out for censorship by the government. And so I think they very well recognize that this may be the Westboro Baptist Church with 60 or 70 members today, but it could be the Jehovah's Witnesses or the Southern Baptists or some other denomination tomorrow. And so I think you definitely saw, I mean, it would be an interesting exercise to change the facts if this were the atheists of America protesting outside of the funeral and saying God hates Christians, right? Would it be, or God, I guess with a question mark afterward, hates Christians? Would it come out as the same case or not? And I would like to think that it would, right? I mean, you'd like to think that the court would be indifferent to the viewpoint that was being expressed, but I think it would have been a trickier case and a harder case, and you might not have gotten the overwhelming vote that you did.
What's next? What do you see as the next big free speech, First Amendment issue point?
Well, interestingly, and nobody knows what to make of this really, but there is a concurring opinion by Justice Breyer that accompanies this decision that I think telegraphs a little bit where we are going next, and that is that there's another element to this case that didn't make it to the Supreme Court, and that is that there was this very sort of long, rambling, very harshly worded tome that the Westboro Baptist Church posted on the internet that they called, or has been referred to as, the epic, again, because of the size and the scope of it. And that speech, in fact, was more pointedly about the Snyder family, and I think would have made for a tougher case had that issue been squarely presented to the Supreme Court, and it was not. But Justice Breyer went out of his way in his brief concurring opinion to say, I don't take anything that the court is saying here today to be addressing itself in any way to the right of free speech on the internet, which is something for us to talk about at a later time. And so I think that's where we are going next. Is where we're going next is, back in the George Carlin 7 Dirty Words case, right? The Supreme Court decided that over-the-air broadcasting on broadcast stations that are licensed by the FCC is subject to a lesser degree of First Amendment protection than is speech on the printed page, because it's sort of uniquely intrusive and it can come blaring out of the radio at children who are unsuspecting and unable to avert their ears. And the court has held since then, in the earlier days of the internet, in the early 1990s when the internet was not nearly what it is today, that speech online is more like print than like broadcasting, and therefore enjoys the full benefit of the First Amendment and not the reduced level that applies to over-the-air broadcasting. But I think you see in an opinion like Justice Breyer at least a willingness to entertain it. I don't predict they're going to go to the FCC and decency standard by any means, but at least a willingness to entertain that medium may be so unique that there are different analytical standards that need to apply.
Any other thoughts on what's coming next?
Well, I do think that the issue of privacy that is raised here, the concept of what is truly private in a pervasive 24/7 news environment, as well as a global and some would say intrusive internet environment in which we've really moved to, I don't know how many of you might be tweeting right now, which is fine, by the way. I just did. But it's become much different than most communicative mediums. It is now becoming just part of our daily thing. And again, the court did set that aside, say, hey, at least one of the justices said we might have some other issues here. And I think we're going to have to address that in this concept of what is private. It used to be close the door on my home, right? That was the doctrine. When I close that door, it's private. Certain kinds of records. We had a practical anonymity or obscurity in terms of public records. I mean, they were kind of held down at the county courthouse or at the state government or in the federal government somewhere on paper. But truthfully, most people couldn't get to them. Well, now I can aggregate that information. And I think that's one of the things, again, not discussed in Snyder v. Phelps was the internet aspect that the family could only see it. The family could only be impacted in a certain physical way. I can see the back of this room, but that epic went out potentially globally, and the tactical decision not to raise that in court was made, and now reserves this issue for another day. But I think we're going to see this issue of privacy from this case and others come up in ways, and also impacting down the line in student law and all sorts of other areas of law. Privacy is going to become a paramount issue impacting the First Amendment.
If I could put my student press hat on for a second here, I mean, I think clearly where we are going is there's an enormous, enormous amount of confusion out there among everyone, the legal community, the schools, everyone, about the level to which a school, a public school, under the First Amendment can discipline students for things that they say and do online when they're not using the resources and the premises and the time of the school. And that's a very ripe issue for consideration by the Supreme Court. There's a case percolating its way up that's at the Federal Appeals Court in New York right now, a case called the Doniger case, and that's the vehicle that I think presents the best chance of the ones that we know of now. I mean, something could come out of left field, but of the ones that we know of now, that's the one that looks like it presents the best chance of percolating up to the Supreme Court and setting the standard. And just briefly, without getting into the details, this is a student who blogs on a private blog after school hours on personal time about a dispute that she's having with the principal and uses some language that is uncivil but not obscene, not profane, just some uncivil terms about the school administration, and is disciplined by the school for doing so, even though there was no disruption to school. In fact, there was no evidence that anybody at the school ever read the thing. It had a tiny, tiny audience of basically her friends and family, and even in spite of the fact that there was no proof of a disruption to school, this was held, at least in a preliminary ruling by the Second Circuit Court of Appeals, to be a punishable event not protected by the First Amendment. It is back before the Second Circuit Court of Appeals now for a final resolution. It's been sitting there as we sit here today for a year and 3 months, which is a very, very, that's like being 13 months pregnant. That's a very long time. And so it's due any day now, and when it comes up, I do think that may tee things up for the Supreme Court. And we need some clarity there. We need some absolute clarity there about where those boundaries lie, because almost every state is enacting cyberbullying legislation, and the constitutionality of that is going to depend on this very question. How long is a school's reach to conduct off campus that doesn't have any physical nexus with the school?
Yeah. The Office for Civil Rights recently came out with new guidance, really advising colleges and universities that get federal money that you need to be concerned with off-campus expression if it involves, say, 2 students who are off campus, and the problem of the harassment might spill its way over into the campus in such a way that, let's say the 2 students, all of this happened off campus, but now the one student doesn't want to be in class with the other student, let's say. So all of this off-campus speech that might be discriminatory harassment that the courts would normally deal with, now that's the university's problem too. So the off-campus speech is really something, and universities, in order to avoid liability, are starting to say, well, I guess we have to now find out what all of our students are saying all the time so that we can stop it. And maybe I have no idea how the Second Circuit is really working, but there are 2 Third Circuit cases for grade school students going on right now involving internet speech, fake Facebook profiles of, I don't know if it's the principal in both cases.
Yes.
I don't remember. Is it principal?
Yes.
Yeah.
And they're different ages, and there's some different circumstances that make them a little bit different. The amount of punishment is a big difference too. One of them got mandatory psychological counseling, and but also they're grade school cases, and so their applicability to adults and college students may not be so important. But I'm just wondering, maybe the Second Circuit is delaying to see how the Third Circuit deals with these 2 different ones, which went in different directions. And one, the student was, it was found to be protected speech, and the other one it was not.
You know, that's a curious thing about the Supreme Court, or about courts. We had 2 opposing views of the 10 Commandments on the same day from the Supreme Court. These 2 cases in the Third Circuit went diametrically the other way, and so they're going to have to be resolved at some point in the Supreme Court about how far to reach it. And this goes back to Snyder v. Phelps, because there's a question in intentional infliction, and really washes over into some other areas, of Mr. Snyder willingly going to find the epic in order for him to be damaged by it. And I think this may be why it wasn't brought up to the court. There was some squishy law, deeply legal term there, as to whether they were going to, because he went and found it on the web. And there's some question, again, as we go, whether these cases, and I think in all 3 cases, they weren't really aimed at a school audience. At least the defendant in those cases, the kids, said they didn't really intend it for it to be circulated in school. With Snyder v. Phelps, there was an early argument that Mr. Phelps had to go online to find it. Well, does the mere fact that you go online and maybe do a search for your name, I mean, does that really invite the damage? I mean, it's sort of a legal principle. You can't claim intentional infliction of emotional distress if you invite the distress. can't yell, "Hey, I'm over here," and then claim that somebody went after you. And so it's a question of just going online. If you're online, or someone tells you about it, and you go online out of curiosity, are you inviting that emotional distress? I think there's going to be, again, this whole area of the web complicates some very well-established principles because of its reach, its intrusion, its permanence. You really can't retract anything anymore in defamation because it's out of your control. Not in the way you could formally apologize in print or take it all back, if you will. And there's no geographic boundary anymore. So it's the web is going to complicate all these things. I think it complicates Snyder v. Phelps for that reason. And we have this unresolved issue about this epic, which was much more targeted. If you get a chance to read that, it's still, I think, online.
Yeah.
It tells the Snyder family that you did this wrong, that you raised your son in an improper manner. I think there's more of that in the Fourth Circuit than there is. There certainly isn't anything really that extensive in the Supreme Court decision. Go to the Fourth Circuit and read that opinion there because they really there's some discussion of this, and read the briefs about it. It's a case that really I think will give you an education in a whole range of law, and issues that are going to be coming up in the future.
Just one point I'd like to make about this case is I think the court makes it really clear that you don't punish the speaker, but they don't really talk about what you can do. And my connection to this case, the Westboro Baptist Church came out to Salt Lake City about 2 months ago and protested. And my son is a senior at West High School, downtown high school in Salt Lake City. They were all deciding how to react to this, and there was a bunch of chatter among the parent network about, fear of violence and such, and should we keep our kids home from school? And I just thought, it's entirely the wrong approach. What you should do is think about having your own counter-protest. And so the students got together, and they had a planning committee, and they had a counter-protest. You had Westboro Baptist Church on one side of the street, and you had the students at West High had their counter speech on the other side of the street. And the news covered it, and it was a great teaching moment. And I think those kids had exactly the right response, that you don't deal with unpopular, hurtful speech by punishing the speaker or trying to suppress it. The answer is additional speech that is tolerant and preaches a different message.
I'm not sure it's on the program, but we have an audience here of journalists and journalism students. Any questions you would like to ask of our panelists while you have the experts here? There is a mic at the back of the room.
Surely there's some of you think we're all full of hot air.
I was wondering if you could comment on a case that legal scholars like yourselves are less unanimous about than the Phelps case. Give an example of maybe cases that divide people in your line more than this case has.
I think the petition cases in Washington State and California, there was a great debate in the First Amendment community. This was an attempt to declare the signing of a petition a private act, a public petition to place some elements on the ballot or reverse some earlier action. And I think a lot of people were very divided over whether those names should be disclosed. The argument of people who wanted to keep them secret was this aggregation of information makes the signers of petitions the easy targets for violent activity, threatened violent activity. And then, of course, the argument from a lot of journalists and others was, wait a minute, it's a petition. It's public document, and we have to vet the signatures and see if, we don't know if the government's really, what if they secretly like the petition and they're accepting all these dead people with signatures, fake signatures. But a lot of people in the First Amendment community are saying, well, wait a minute, this may not be a public act, and you're going to shut down petition by subjecting people to this new form of harassment. So, one area.
Yeah, I think actually, that's perfect, because what you're seeing there is a collision of two deeply held values, which are in that case irreconcilable. the interest in transparency and the interest in the ability of people to speak anonymously, which is a cherished right that the Supreme Court has vouchsafed again and again, that anonymous speech is protected by the First Amendment. And that's something that the media in other contexts will go to the mat to defend. Relating to that, and this is not a case that's being litigated today, but it won't be long. Many of you have heard about the case involving a University of Wisconsin professor whose emails were sought by the Republican Party through a Freedom of Information Act request. And this is that same tension that Gene has just put his finger on, the tension between the transparency in government, which is this is a person who's being paid a very nice salary by the state of Wisconsin to do a job, and we have a right as public taxpayers to know what he's doing when he's sitting in his office using his government-paid computer, right? On the other hand, we cherish the right of people to engage in the political debate free from harassment, and that is what he claims is going on in this case, that his emails are being sought for harassment purposes. And I think that really is going to cleave the media and First Amendment community. I mean, an organization like ours, we are purists about the First Amendment and true believers about the First Amendment, but at the same time, we're advocates for journalists, and journalists need transparency, even sometimes at the cost of some people's privacy.
I had another question about two cases that are being litigated right now, the Phoebe Prince case and the Phoebe Prince case and the Tyler Clementi case. They're both cases that have sort of cyberbullying components. And I was wondering to what extent the people who are accused of bullying these people to death, in your view, should be liable for that, and to what extent campuses should or school administrators should restrict speech on the basis of the possibility of that kind of harm.
I can speak to the Tyler Clementi issue because it involved college students, since we paid a lot of attention to that at FIRE. One of the most important things to know is that the actions by the roommate and the roommate's friend were already illegal. It was already an invasion of privacy to tape someone having a sexual relation or to broadcast it as it was happening. So the laws already were pretty clear that you can't do that. And I don't think people really, I haven't seen anybody say that that kind of activity is okay after all. So the next question, though, is if the remedy is to expand cyberbullying law to include all kinds of activity and expression that weren't banned before, including protected expression, then in the name of preventing things that already the government could prevent, or at least in theory punish, we're adding all of these protected things into the list of things that are unprotected. So the Tyler Clementi Higher Education Anti-Harassment Act of 2010, which has been reintroduced as the 2011 Act, goes way too far in redefining what harassment is supposed to be. So if you agree with the Supreme Court's 1999 Davis versus Monroe County Board of Education definition that I gave when I was talking before, speech has to rise to the level of conduct to be harassment. And it has to be a conduct that is so severe, pervasive, objectively offensive, subjectively offensive to the victim, directed at that person because of who they are. If you've met all of those prongs, then you've harassed someone. And if you fall short of that, you haven't, according to the Supreme Court. Now, that's, I think, a definition that people might say, well, that's too strict or it's not strict enough. And what we see in this new act is making it much less strict, and in fact, commanding universities to have a much looser definition of harassment that's going to encompass a fair amount of protected speech.
Thank you. I want to just add to that. I mean, you asked about these cases working their way through the justice system, and in both cases you have criminal authorities looking at whether there's prosecutable conduct in basically driving a person to suicide through harassing behavior. And I would say, as between the criminal justice system and the school disciplinary system, I would much prefer to see those cases work their way through the criminal justice system, because the school disciplinary system is just not built to provide the kinds of due process protections that are necessary when you have serious conduct of this gravity. There was just a statistic reported in the Washington Post last week, fascinating statistic. In my area, Fairfax County, Virginia, there's a group of parents that's trying to reform the school disciplinary system in Fairfax County. They used the Freedom of Information Act to get the results of every disciplinary appeal hearing over the last 6 years in their county in Virginia. 5,025 disciplinary cases over a 6-year period. Do you know how many disciplinary appeals the students prevailed in during that 6-year period? 0. 0 out of 5,025. There wasn't even one person who was sort of accidentally right out of that 5,025 cases, right? And so what we're seeing is this is a system that is just not effective at providing due process. And so you really can't trust that system. You can't put more weight on it to try to police off-campus civility and things that are borderline criminal in nature when it frankly can't even bear the weight that we're putting on it already.
You know, I talked a lot about new technology and the interweb and everything, changing things, but, you know, in the school cases, particularly in the Third Circuit, Blue Mountain and I always forget the other case, but...
Layshock.
Thank you. You know, I kind of wish that the offended school administrator had sued for defamation, because I think it would put it in its proper locale. I mean, if I'm really defamed, and some of this was pretty scurrilous conduct, if you will, or allegations or claims or portrayals, we'll sue for defamation. I mean, I don't know why you suspend somebody when they've trashed your reputation and said you're a pervert and child molester and all these other things. I mean, I wouldn't want to stop there. And in some cases, these administrators were sort of praised for not lowering the boom on. And, you know, I'm sorry. If somebody said that about me, I may or may not sue because of the job I have. But if I weren't in this role, I probably would sue somebody for defamation based on what I read. And I think we're much more equipped. We have a much stronger body of law. We know the rules and regulations on both sides than trying to extend the school's reach or create some new zone of privacy or public persona versus private persona, as Snyder Phelps tried to do. You know, I think we can handle these. I remember a case early on involving Microsoft. It wasn't a First Amendment case, but it was at Microsoft. And a judge cited, I think it was a 1848 Wells Fargo, Western Union case, a decision. And normally they won't go back quite that far in the decision. But he said, I wanted to make the point that this is the web and new technology, but, you know, the same old standard applies to whatever this commercial case was engaged in. And I thought, well, that's a great point, is that sometimes, even though it's a new medium, we have rules and regulations to handle the conduct that's involved. So I think, you know, again, I think maybe Snyder Phelps went up on the wrong issues in some ways, and some of these school cases are certainly, to me, why is the school litigating this?
Some people in this room are already familiar with this, and 2007 was the last time that the Supreme Court had a case that involved the rights of students. And in that case, the Morse case, the student lost and the school prevailed in a First Amendment dispute.
Bong hits for Jesus case.
Right, it's called the Bong hits for Jesus case because that was the expression that was at issue. Well, at the time, most of us thought that this was kind of a wacky decision that was not well grounded in legal doctrine. And I will tell you that decision only looks more extremely wrong now with the benefit of the hindsight that we have with 3 more years of the Roberts Court, right? If you look at what the Roberts Court has ruled in the last 2 years on the First Amendment, right, they have ruled that corporations can dump unlimited amounts of money into campaigns in order to buy influence. They have ruled that you cannot make it a crime to sell somebody a video of a woman in stiletto heels stepping on a kitten for sexual gratification. They have ruled that it is okay to stand outside of somebody's funeral with a sign that says God hates fags, but by golly, if you are a student and you want to make any comment at all about illegal drugs, that's punishable conduct, not protected by the First Amendment, right? I don't think so.
That case is so illustrative I just love the fact that when the student initially was called into the principal's office and cited, I believe, Jefferson and Madison, that she doubled the suspension. And I thought as an educator, you really should have given the student credit for quoting Jefferson and Madison and reduced it. I think she reversed that, but I believe initially she doubled the suspension. That Longheads for Jesus case was, but bad case, bad law. And I'll tell you what, the scary thing about it, the scariest thing for me, is that the court went out of its way. Justice Roberts loves to put this language in there. It's a very narrow decision, applying only to these da-da-da-da. They said that this only applied because the Longheads for Jesus was a drug message, and at least to the 9 justices, and or the majority of the 9 justices, and that part of the mission of schools is to fight drugs. So that very narrow. I will tell you what, within 4 months, a district court judge in Missouri cited the case in saying part of the school's mission is to fight violence. And so we're going, so this narrow decision does just one more traction of saying to students, we're going to get you, to me, which is probably not what the Supreme Court language would say, but I view it that way. We're going to get you. We're going to find a way to silence you, shut you up in the name of order and avoiding another Columbine, which is the paranoid fantasy and fear that everybody has.
Thoughts of Jefferson and Madison is a good note to end on. On the behalf of the First Amendment Day Committee and all the sponsors of First Amendment Day, thank you very much. One quick reminder, Frank Lamont is our keynote speaker tonight, 8 o'clock in Sunroom. Well worth your time to come, I'm sure.
Except I already gave you all my best one-liners.
Oh, no, he has many more, I will tell you.
Thank you again very much.